In the Karen Read case, all of the experts are now lined up in the target of the special prosecutor. And also in this episode, what is happening with the lead investigator, Michael Proctor?
Could it be that the Karen Read retrial looks completely different than the first trial? I'm Lainey Law.
And I'm attorney Andrew Myers.
And do we think that Michael Proctor is going to testify this next time coming up?
Well, before we get to answer that question, we really need to know what's going to happen in these disciplinary hearings. There was one disciplinary hearing and the media was kept out. So we don't know exactly what happened in that hearing. So it was continued to a second date, February 10th. And so we don't know what is going to happen to him. Most logical people think that he will be, permanently terminated from the Massachusetts State Police, but we do not know that yet. And he is, like it or not, folks, he's entitled to a vigorous defense, and there's a union that'll defend him and he'll defend himself. So, whether he testifies or not remains to be seen, as well as which party would call him. The real issue in this case right now is the special prosecutor, Hank Brennan, came in on the very first hearing. He told Judge Beverly Cannone that I am working to make this a more streamlined trial. And we all thought that meant, instead of having the Commonwealth putting on something like 67, 68 witnesses, that they would pare that down. No. Anybody that said that, including me, was wrong. He is really working on trying to get rid of all of the defense's expert witnesses one by one. He's trying to pick them off. But is that really what he's doing? Or is he just, in my view, doing the equivalent of conducting depositions of these people? In a civil case, we civil attorneys do depositions. You file a claim, then the insurance companies with unlimited funds, start deposing everybody in the world, your client, your client's family. What did they observe? What did they see? Everybody in the world. And why are they doing that? Not just to run up the bill, although that is part of the reason. Part of the reason is because they are now locking in the testimony of all of those people who may not have prepared themselves adequately for the actual trial, so that when they come to trial, now their testimony is locked in on paper under oath. And if they deviate from that at all, they are impeached, or at the very least cross-examined. So in my mind, that is what Mr. Brennan is doing in this case. With the judge sitting there watching, he's deposing all of these people. And here's why I say that. Here is the order that the court issued on Dr. Russell. Memorandum of Decision and Order on Commonwealth's motion to exclude the testimony of Dr. Marie Russell. Now, a lot of people said, the defense won. They get to keep Dr. Marie Russell on the stand. Nuh-uh. The judge really did some damage to Dr. Russell. She did an analysis. Accordingly, the court finds that Dr. Russell's testimony satisfies the 5 foundational elements and therefore will allow Dr. Russell to testify as to whether the abrasions on John O'Keefe's right arm were caused by a dog. So you think that's a victory for the defense? Not really. The judge then took a swing at Dr. Russell 4 times. In so ruling, the court recognizes that on cross-examination, the Commonwealth demonstrated, among other things, that Dr. Russell's expertise primarily concerns the treatment, not the identification of dog bites, that her evaluation of the abrasions failed to consider all available information, that she has not compared the abrasions with the dentition of the German Shepherd in question. That's a big word for arrangement of the teeth. And the 4th swing that she takes is that Dr. Russell's opinion is inconsistent with findings that there was no canine DNA in the area of the victim's clothing near the abrasions. However, the court concludes that these issues go to the weight of Dr. Russell's testimony, not its admissibility, and can be addressed during cross-examination. What did I say in our last episode on this subject? What did I say in the last episode.
It certainly looks like they're allowing her in, but saying, you know what, you have every grounds to say she's not an expert in this, despite the fact that she has to treat dog bites versus vehicle injuries. How can we prove that she's an expert?
I said in the last episode that a law school first or second year student who's taken Evidence 101 knows that there are two hurdles that any evidence has to go through, whether it's a document, a photograph, or getting a witness on the stand. There are two hurdles. The first one is admissibility, which this expert, in my mind, was fairly certain that she was an expert. Once you get that evidence, whether it's a document or a photograph or an expert witness or any witness, then the second issue after admissibility is credibility. You have the right to cross-examine. Any witness must face the opponent's attorney cross-examining him. That's pretty simple, but that we went through 2 days of hearings for this. And it just seems, again, that the Commonwealth just wants to depose these witnesses just to lock in their testimony. It makes no sense that they're, wasting 2 whole days on these hearings. The next one, and we're not going to spend too much time on this one, but because we did this in a previous episode, but the Commonwealth is going after witness Richard Green. He's the forensic guy that looked at Jennifer McCabe's telephone and said, yes, that controversial text or search in the middle of the night, Haas Long to Die in the Cold, was in fact made at 2:27. So that's the second of 4 experts that Mr. Brennan is going after. Here is his motion. He used that word debunked at least half a dozen times in this motion. I fully expect that in law school, if I had written a motion and put debunked in it, I probably would have had it thrown back in my face. But anyhow, so he's taking a shot at the expert. He went through the fact that he felt that Mr. Green's affidavit was absolutely wrong. And Mr. Brennan says that in response to Mr. Green's misconstructions, strong language, the Commonwealth retained its own experts, and the experts basically showed that Mr. Green's testimony had been debunked. There's that word again.
Favorite word.
Yeah. Richard Green's debunked opinions are not an example of a battle of the experts, best left to be resolved by the fact finder, but instead an attempt to infect the jury with an inadmissible opinion that is not premised on reliable digital forensics. And trying to be as objective as I can, this argument kind of mixes apples with oranges, because the issue is, in fact, admissibility versus credibility, the two different things that go into this. And he kind of mixes that in with his idea of what a battle of the experts is. And everybody knows what a battle of the experts is. I put on my expert to say that the books behind me are green, and you have your expert and say, no, the books behind you are red. When they both have a little bit of both in them. That's a battle of the experts. My expert says A and your expert says B. That's not what we're talking about. So that's what I mean by the fact that this argument is muddled. What we're talking about is whether it is an issue of admissibility or an issue of credibility. And in my view, and the view of a lot of other people that I've read and talked to, the issue is that Mr. Green's testimony is admissible. He's an expert. He's testified in many, many, many trials. I believe he said 2,000 trials. He's been allowed to testify as an expert. But Mr. Brennan is saying, no, we have to have a Dauber-Lanigan hearing to assess whether the defendant may call Mr. Green to testify to these two, again, here we go, debunked claims in her second trial.
A lot of extra hearings, a lot of funds being spent thinking about that. We already have one expert that's going to be following through. It's a lot of resources to keep trying to tear down all these people.
And again, he's just trying to depose them. In Massachusetts, and I don't know about other states, but in Massachusetts, criminal defense attorneys rarely, if ever, do depositions. We civil attorneys do them all the time. In one case, you might do a half a dozen depositions. You might do more if it's a case that involves experts, if it's a case that involves, scientific theories, if it's a products liability case or a medical malpractice case, you could do 20 or more depositions. In a simple case, you might do 6. But I talked to one criminal defense attorney just before we went on here, who will remain unnamed, but he said he's been practicing law for over 30 years, and I know that to be a fact. He's done 2 depositions in those 30 years.
Oh my gosh.
The criminal people just do not do depositions. Now, by analogy, they might do motions to suppress where they get a chance to have a police officer come on the stand and they get to ask as many questions as the judge will allow them. But usually the judges keep them on a pretty tight rein, which is similar because now they're, in court, in open court with the judge and opposing counsel there. They get to question the police officer in a motion to suppress. But in criminal cases in Massachusetts, depositions are rare. Mr. Brennan is trying to depose all of these people. And the final one is he's going to be going after the ARCCA experts.
Oh, no.
These are the experts, Daniel Wolfe and Andrew Rentschler. Nice first name, Andrew. And he has put a heads up. The first motion that he filed was to get discovery materials on them. Now, what Mr. Brennan is saying is, I foresee that they're not going to be able to comply with my discovery request. And so when that happens, then at that time, I'm just telling y'all that I am going to, at that time, go after them. Not in those words. The history and complexity of the ARCCA's witnesses' employment and directives are muddled, Mr. Brennan says, and unnecessary to recount for the purposes of this notice. Rather, it is expected that if the defense attempts to proffer either or both potential witnesses, it will be unable to comply with Rule 14 obligations, that's discovery. The Commonwealth does not allege the defense will be negligent or unwilling to comply. Rather, it is expected that given the handling and employment of these witnesses, the defense will simply be unable to meet its obligation. The Commonwealth provides this notice prior to any hearing or filing a motion to preclude and prior to the filing of a DKK 442, Commonwealth's motion for reciprocal discovery pertaining to employees of ARCCA. The purpose of this notice is to alert the defense and the court of the Commonwealth's expected position, giving the trial date and the impact exclusion would have on the defense. So it's really a heads up that not only was Mr. Brennan able to effectively, in my opinion, depose Dr. Russell for 2 days, Richard Green's testimony is coming up, and then he wants to do the same thing with the ARCCA experts. It's really unheard of in a criminal case.
I was going to ask, it feels a little sassy as this normal, but you said it's unheard of, so...
It's rare. A deposition is done in a criminal case in Massachusetts if it's likely that a witness is not going to be available for trial, i.e., they might die before the trial. They might move to Afghanistan before the trial. They might be, something like that. But it kind of, singes one's brain to think that someone would come into a case like this and have fun with it and just do depositions in open court. And then have the judge list out 4 reasons that the prosecutor scored points with the expert. And, hey, Mr. Prosecutor, here's 4 things you can ask her about.
Yeah. Oh, and that to me it reminded me of when the would you like to strike that? It was like a little note at the bottom is just like, I'm not going to go against what I said previously because I already let them in once, so it would be awkward if we didn't let them in again. But I'm going to give you a tip. That's how it felt to me.
It's a little bit unseemly. That's as far as I'll go with that. But the next thing that's happening right now is Mr. Proctor. He had a day of a hearing on what is the Massachusetts State Police going to do with him. A lot of people thought that he would be summarily terminated. Oh, no. This is the Commonwealth of Massachusetts. He has a right to a hearing. The media was not allowed in. The newspaper and TV reporters had to stay out in the cold. Mr. Proctor had a full day of a hearing. They came out, they said, oh, we're going to continue it for another day. So what happened in that hearing? Here is an article that was in the news in the greater Boston area. And where do we pull this down from? There we go. Boston Herald, Flint McCoglin. Good reporter. We've had him. We've had his work here. Disciplinary hearing for suspended Massachusetts State Police Trooper Michael Proctor continued to second day. There he is. He's on the stand. That's what he looked like on the stand in trial 1.0.
So I'll start off reading this article.
Okay.
Suspended Massachusetts State Police Trooper Michael Proctor's trial board disciplinary proceedings will go on to a second day. Proctor's trouble publicly began when he testified during the murder trial of Karen Read last summer. During these tense examination by the prosecution and even more intense cross-examination, Proctor admitted to inappropriate private texts, appropriate they were, that he made as the case officer investigating Read.
Yeah, you continue reading this, but I just want to interject my comment that, the Herald, when I used to ride the subway every day, the Herald, it's one of those papers that, they can pretty much say anything, but even they couldn't print all the stuff that Mr. Proctor said on the stand. So I'm sorry to interrupt you.
No, yeah, I mean, that's a funny point to bring out because even this next quote, she's a whack job expletive. Proctor read from compilations of text messages he sent to friends as he looked at Read's phone. The last word was a derogatory term for a woman that he first tried to spell out before a Judge Beverly Cannone told him to read it the way he wrote it.
Yep.
For those that remember that was cringy. I mean, all of this is a cringe. I can't even imagine messaging people like this. It's like, yes, she's a babe. Weird Fall River accent, though. No but. And but is in parentheses because he used another word for but.
Yes, he did.
He continued under oath on June 10th, 2024, my birthday. That's
I didn't
great.
know that.
We love that. He also texted them, no nudes so far, as an update on the search through her phone. He also testified that he told his sister that he hoped that Read would herself.
That's horrible.
Yeah. Well, that's what I'm saying. It's just like a lot of people, and I think this is a big reason why this trial has so much publicity, is because these are the people that are supposed to protect you. And then just imagine like you're trying to have an issue going on with the police, and then you're thinking now they're talking about my B word.
Yeah, exactly. I've talked to a couple of cops off record who I know, and they just shake their head at this whole case, the way the whole case has been handled from start to finish. But this in particular, that a cop would, a state police trooper would be talking like this at all, was just, they're shaking their heads and saying, now they're going to retry this a second time and give police even more bad publicity.
Mm-hmm.
So, oh my God. I'm sorry I interrupted you again.
No, you're good. On Wednesday, Proctor sat through a full day of trial board proceedings at MSP General Headquarters in Framingham. When that concluded in the late afternoon, the board decided to continue for a second day on February 10th. Neither Wednesday's proceeding nor the second day is open to the public. Proctor was relieved of duty on July 1st of last year, which was the day the Read trial concluded in mistrial. He was suspended without pay a week later. The state police finished its internal affairs of its investigation last week and convened the trial board to determine the next step in the disciplinary process. When the board makes disciplinary recommendations to the superintendent, who determines the final outcome. A state police trial board shall hear cases regarding violations of rules, regulations, policies, procedures, orders, or directives, states the department's rules and regulations. In the event that the trial board finds guilt by preponderance of the evidence on one or more of the charges, the trial board shall consider the evidence presented by a department prosecutor pertaining to the accused members' prior offenses, disciplinary history, and shall make recommendations for administrative action. The rules and regulations state.
So this could go on and on and on, and this could continue for a while. I think so what they're saying is it could continue beyond February. It would seem a pretty cut and dried thing to me. Even as an attorney, I would think it's a pretty cut and dried thing. But I mean, I guess not. There are procedural steps that both by regulation in the Commonwealth, but by the union contract that allow. And I'm not saying that there shouldn't be protections, but in a case like this, it seems to me, and I know I'm going to get negative comments. I know it. I see them being written now already. It would seem like in a case like this where it's so clear, it's dragging it out and dragging it out and dragging it out. And I don't know. The governor has been so silent on this ever since all of this happened. She made one little statement, and that was about it. It's a pending case. I can't really say anything, but it would seem to me that the leadership all the way to the top in Massachusetts is just. I guess I'm just guessing that they're so ashamed of themselves that they don't want to say anything because if you come out and you say anything, that is kind of, it just highlights it, brings more public attention to it. So I don't know. It's not a good day for the Commonwealth, but that it can drag out for this long, I don't know. It's not a pretty picture. And I saw an article in one of the newspapers that I didn't bring in to this episode that the law enforcement people in New Hampshire are watching this closely. The New Hampshire law enforcement people are looking at this closely, not only shaking their head, but wondering, why is this procedure taking so long? How usual or unusual is this for Massachusetts? And the article went on to say that the other New England states, the smallest state in the union, and we all know that's Rhode Island, and Connecticut must also be watching this. So I don't know. It becomes a huge issue, I think, for a lot of people, not only just the other police in the other districts, because you think about any other job that you would have, any job that the people watching this, if you got your phone taken away at work and they saw these messages, if these are messages you were sending to your supervisors and stuff, anybody else would get fired from this. This is very bizarre. I don't know. Well, that in a prior life, a long, long, long time ago, my first job out of high school was on a loading dock. And I loaded and unloaded tractor trailers. And anyone can imagine, especially if you've worked in a loading dock, the language that we heard, not me, of course, the language that we heard on a daily basis did not even rise to the level of this kind of thing. We would have been fired on the spot. There was even though I was actually technically a member of a union, I think if we had said some of the stuff that Proctor said, we would have been kicked out of that loading dock warehouse faster than the tractor trailers pulled in and out on an hourly basis. So, well, just also imagine working there. Imagine if there was a supplier or someone visiting and you sent a text to your boss saying oh, weird accent, has no butt. Yeah. It's just they would say no, you're gonna get us in trouble for sexual harassment. You're out of here. Yeah, get out of here. Just, goodbye. So, oh, good grief. I mentioned our commenters, and our pithy commenters are always out there. Some good, some bad, some indifferent. And did you want to start? I forget. Yeah, I'll take over. So Tracy talks a lot. 1513. The Commonwealth seems to be continuing on the path of disproving a dog attack instead of focusing on proving their actual crazy theory that a vehicle was involved in John's death. I really hope that the defense can stick to highlighting the impossibility of any vehicle involvement, because without that, there is zero evidence that KR could even remotely be responsible for the dog attack. The question of whether he went inside the house or not is all secondary. And I think that's a good point where they're spending more time proving that it wasn't the dog bite than trying to prove that it was a car accident. Yeah, I would guess that Mr. Brennan might be sorry that he had hoped for it if he would be able to get all the experts out. And my prediction is that he's not going to be able to knock out Mr. Green or the ARCCA experts. But if he did, that just puts more focus on the bad parts of his own case, which is Proctor and the others and the solo cups and, all of that kind of stuff. So, be careful what you wish for. Isn't that what they say? Yeah, no, I think that's a great point where it's going to bring focus on a lot of other issues in the investigation. So our next comment, Jenna Justice 24. It's terrible what this is costing Karen Read. The Commonwealth needs to let go. They are spending the taxpayers' money frivolously. Shame on Massachusetts for allowing this. Yeah, it's an expensive proceeding. Any trial is expensive, but to go to the extent that they have here, yikes.
Another hearing and another hearing and another hearing. I'm not even going to try with this name. I apologize. 8591. Hopefully that sounds familiar if you're hearing this right now. The interesting part was at the end of the ruling. The judge added comments that seemed to be helpful to the prosecution. That seems to be consistent with her behavior in the first trial. Yeah, I mean, that's what a lot of people take issue with. And that's what we've pointed out as well, that it definitely seems like she's giving a little tips.
Yeah, that's the last paragraph that we read there, where she pretty much highlighted 4 different areas that the prosecution can use. I'm sure they knew that, and I'm sure they have a notebook full of them. But for the judge herself to list, hey, guess what? You damaged her. Not only did you get a deposition of her in open court with a transcript that you can go through with a highlighter and a fine-tooth comb and, get cross-examine and impeachment material. But also, in addition to that, here's my outline of stuff that you can use come trial. So pretty unusual in my view. Warren Howell, 7989, says, and I found this to be an interesting comment, the tech data indicates the speed of the tires were turning, not the speed of the vehicle. If the vehicle was on a mechanic's rack, it would show the same data. It is not showing the actual movement of the car. It's not GPS. The tires could spin on the icy road, but not move. And the data would show that not actual movement. I thought that was really interesting.
Mm-hmm. Yeah, I don't know too much about that type of technology and what it specifies, but I would assume that if they're commenting this, it's coming from some type of knowledge.
Yeah, I mean, because we have all been led to believe that the Lexus was backing up at 26 miles per hour. What this commenter is saying, no, the wheels were spinning at a rate that was their full traction between the wheel and the road would be equivalent of 26 miles per hour. So that's the movement of the wheels and not necessarily the movement of the car. I think we've all been, at least in New England, we've all been in the position where we're trying to move and the tires just spin. So,
But I think also like 20 plus miles an hour going backwards, just in general, like, can you think of reversing that fast? Like sometimes when you're going through neighborhoods, you can't even, the neighborhood you're driving through so slow, you can't even get to 20 miles an hour. So that's an interesting thought too.
I'll have no comment on whether I've ever been in a car that traveled backwards that fast. I'll just take the Fifth Amendment on that. While you can take comment number 1.
Yeah, so Sherry Thompson, 1672. I'm sorry, as a prosecutor, one does not make this kind of attack on the defense experts. You don't concentrate on disqualifying all the defendant's experts from testifying at all. You cross-examine them, but you don't try to take the defendant's defense away. A prosecutor, his function is to effectuate justice, not get a win at all costs. Mr. Brennan seems to have forgotten his old prosecutorial days and is acting like he's still a defense attorney. And it does, and that kind of relates to the first comment that we read, that it does seem like it almost seems like he's just trying to pick off and win via that versus just painting the case stronger.
I would say that if we were to summarize the material that we did in this episode, this commenter did it for us. So thank you, Sherry. If you really are a prosecutor, email me. My email, it's down in the details section, about the law podcast at gmail.com. I think I'm allowed to say that. And if you're really a prosecutor, let us know. Maybe we'll talk in a future episode. So that's it for our comments. We go on to our The World is Watching. And this is just comments that we've gotten on our Karen Read episodes. We're now up to 41 countries. And there's only one new country. I felt bad this week. There's only one new country. It's Namibia. Now we have 3 different African countries. We have South Africa, we have Ghana, and now we have Namibia. So,
yeah, and if you're watching this video and you don't see your country listed here, be sure to comment it down below. We appreciate you guys from all over the world watching us.
Oh, absolutely. And you know what I was thinking this week? If you're following the news, I never knew until recent news events that Greenland is not a sovereign, independent nation.
I didn't know that.
I never knew that. I've just learned that Greenland apparently is, do I want to say owned, or it's a protectorate, or it is under the political watch of Norway. It's part of Norway. So I never knew that. I had never knew that. I mean, they are an independent, island, and they do have their own government, but they are under the watchful eye of Norway. But if there's anyone in Greenland that is watching, we will respect your sovereignty, and we will put you on the list. We do have Norway. They're on the list, as are a lot of other countries, but we're up to 41. So if anybody tells you the world is not watching, and this isn't just a list of stuff we put up every week to kill time. Believe me, we have enough stuff to go over every week. There's just so many things happening in this case. This case is being watched by the world. It goes back to what we were talking about before when we were talking about Michael Proctor. I mean, I would like to think that if something like this happened in another state, I'm not going to say the state should sweep it under the rug. That's not my point. My point is to draw it out like this and make it take so long and have top echelon officials in the state kind of looking the other way and not saying, yeah, we got to get this guy out of here. It's really something. So the whole world is watching this disgrace.
No, I mean, that's a great point, that if he, isn't just, if he would ever be allowed to proceed in law enforcement, that how is the world going to recover from that? How are you ever going to trust the people in power at that point? I
think if somebody on a loading dock, despite putting certain words that I'm not going to repeat here in 14 times in every sentence, I think if they spoke the way Proctor did, they'd be out on their butt pretty quickly.
No, I definitely agree with that. I've never had a job that anything like that would fly.
No, anywhere. So I always put you on the spot and say, you have any final thoughts?
Oh, gosh. I'm going to say comment the bunny emoji if you made it this far. I love it when I see the comments and you guys are using our emojis. Thank you guys for your feedback. And like we just saw in the comments, you guys do give a lot of good feedback, and we appreciate seeing this. It's crazy to see how this case is going to develop, and I am curious to see what happens with the retrial, because it really feels like we're going to be watching a completely different trial. But that's all I got. Thank you guys so much for watching.
Yeah, my final thought is that when Mr. Brennan first came into the very first hearing with Judge Cannone, he said that he wanted to make the trial more efficient, and I wrongfully thought that meant that he was going to cut down on all the witnesses that they put on. A lot of the stuff, in my view, was not relevant. We went on all these different trips to Aruba, et cetera, et cetera, et cetera. And in my mind, I thought that's what he meant by paring down or making the trial more efficient. We were all wrong. No, what he meant was he was going to take out after the defense witnesses. That's where we are. I don't like rabbits. You can leave your rabbit emojis, but they eat my garden this summer. So
That is true.
I do not like rabbits. I don't like them at all. But with that thought, I hope you all have a great weekend. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.